That should be reasoned out, is what.
May I answer?
Yes.
So first part is not reasoned out.
Yes.
First part is that. But second part, your lordship query is more important. Well, then, if your lordship were to accept that as a principle, then it is a case of presumptive bias. Then your lordship is not doing, kindly see what your lordship is really doing. I'm answering my lord's query on an argumentative basis. My lord has put a very important question.
There was a clarification.
No, it's a very important question. But just see, suppose your lordship's formulation as a question to me, only to elicit from me. Suppose your lordship's formulation was correct. Just for a minute, obviously your lordship is not giving any, lordship is only discussing. Suppose your lordship's formulation was correct. It would mean exactly what I said in the previous sentence.
Why not?
Presumptive, assumed bias in every case. Well, tell me which case your lordship will have of a sanction where your lordship will not have to apply this principle. But the law, the constitutional law is not that. Because your lordship then has the moment, then what is your lordship doing? Then my lord has in the constitution, A, B, C, D are only 4 discretionary powers of the governor. My lord is making this a fifth category. Always. Always. Then, Malus, why does MP go on? MP, Malus, doesn't go on the bias. If presumptive bias was correct, it had to be finished. It goes by analyzing that the reasoning of the cabinet is not right. It is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher pedestal of irrationality.
I'm very grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malus, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malus. I hate to say this, but possibly the governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a 6th category of discretionary power of governor. MP doesn't say so. Secondly, if my lord's the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality? Doesn't need to. Your lordship not to waste your lordship's time to go to manifest irrationality when it's presumptive bias.
It was only a clarification that.
No, I'm not saying your lordship. I'm answering your lordship's question. The governor doesn't have to waste his time. If he has, why should he examine manifest irrationality? So suppose, and there are 2 categories. One is, your lordship has given me the category where which cabinet will go against. Of course, in politics there are enough cabinets which go against me. It is not,
it is
so sanguine and so uniform as your lordship might think, These are very turbulent waters, to put it mildly.
Yes, sir.
But that apart, your lordship is not looking at the other aspect which my learned friends will, my learned friends are not looking at the other aspect which your lordship will appreciate. That cabinet, if it gives, forget this case for a minute. I'm testing your lordship, the proposition. If the cabinet in a hypothetical case gives perfect reasons, right, it says this chief minister has done nothing.
That's what the cabinet noticed in the case.
I'm not saying my case.
Yes.
Forget my case.
All right. Hypothetical
case. That this cabinet has said that this chief minister is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be developing all this. It's a very, very interesting case, fellows. 23 years. Well, in 23 years, at least 23 been involved in this. The list of dates the lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man has been a minister from his 1984, I think he became a minister in the 80s. Across, he's held many portfolios. No particular portfolio on this issue, no particular file, no particular decision, no particular recommendation, no particular approval. Your lordship will not easily find a case like that. Your lordship finds. Now I can understand a governor saying, despite this, I find Mr. Singhvi's reasoning wrong by 1, 2, 3. But more importantly, apart from Mr. Singhvi's reasoning being wrong, I find that Mr. Siddaramaiah is complicit or is involved prima facie or needs to be given sanction prima facie because of ABC. He doesn't say it. He doesn't say it. He doesn't address the issue. Which brings me to the next point. And therefore, very important clarification. I'm very genuinely grateful for your Lordship's query. Two answers to that. One, your Lordship is not carving out a new category of presumptive bias. Two, MP, which is the only case relied upon for only by the other side, forget the other side, by the governor, is a case where they did not take up apparent bias in a cabinet governor case. And three, it must show, therefore, a perverse 2 plus 2 is equal to 5 error amounting to manifest irrationality, which the governor has not said. He's not even said so. If he had said so, I would have shown he's wrong. But I don't need to show that because he has not said so. Now, which is why, it brings me to my third point. It is because of the previous point that my learned friends do something very extraordinary. That is, the state government. I'm sorry, the persons representing the governor, not the state government, the persons representing the governor. Of course, governor acts to the state government, but he is represented by a separate council. Very extraordinary thing. Keeping in view that there is nothing about manifest irrationality. There is nothing about any reason by the governor and nothing reflecting the process of ratiocination. A lot is put it very nicely in many judgments. These are the materials. That is the conclusion. The chain which links the material with the conclusion is known as the process of ratiocination, the process of reasoning. Now, there is no reasoning about why he is guilty, prima facie, or why the cabinet is wrong. The only reasoning is that the presumptive doctrine my lord put. Per se the cabinet, per se the chief minister, therefore I must act. Why I must act is not there. Which is why a third point is pressed into service after the case starts. What is that third point? Knowing that there is no manifest irrationality commented by the governor, knowing that he has not dealt with any issue about Mr. Siddaramaiah, knowing that he has not found any reason to deal with the cabinet itself. They say now, after the case is started, we will not file an affidavit. We will produce files. And I mean that, like Alice, it gets more and more curious. So first thing is, I will produce files. Files are produced. Second thing is, in the files, there is only, if your lordship will look carefully, a chart saying two versions. Version 1, version 2. Always be two versions, There is hardly a case which does not have two versions. Life is all about, grey, very rarely black and white.
Two versions in the minimum.
Minimum, yes. If not 3, 4. Absolutely correct.
Multiple versions.
Our religions say that it's multifaceted use. There is no relativity doctrine itself. Everything is relative. Time and space is also relative. What about versions? Versions will be many.
Minimum 2 versions.
Minimum. Yes. He then puts the two versions, and in the entire bunch, big fat bunch given to your lordships, he doesn't say anything except at the end, I think it should be given. But more importantly, none of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. There is no law that I know of that you produce material and say you deem this sanction order to be valid, because at the back of my office, people gave me 5, 10, 12 versions with 1,000 pages of files. That is like saying that I will be the inscrutable sphinx. Behind the inscrutable sphinx, the pharaohs put a lot of gold and a lot of saman inside.
The silence comes about.
So I will remain the sphinx, but the saman behind in my grave can speak for it all lying in the...
That's right. Inscrutable face of the sphinx has something behind it which cannot be projected by that silence.
And your lordship as a judge should be deemed to validate the inscrutable face because of the saman behind it. But interestingly, that huge treasure house of saman is not finding a word of reflection in the order. I can understand. Nobody is saying that the governor is a judge who's writing a 50-page judgment. Nobody is suggesting that. The governor could have given some reasoning culled out